May I please, Your Lordship? Lord, I'd like to mention for listing of a matter for admission. Can it be listed on Friday?
29th, Friday, 29th.
Lord,
29th of September.
the matter is a little bit urgent.
What is
Can
the
it be
urgency?
eviction matter? Lord?
Eviction matter, admission, what is the urgency? There is a stay order.
Lord?
There is a stay order.
No, my lord.
Then,
Because my lord, I have already been evicted from the land, my lord.
yes,
And that this is the time, my lord, the time for growing crops has come. My lord.
25th September.
Then I have another matter, my lord, that is with regard to construction of PMAYG house, my lord. So on the same day, my lord. Obligation.
Supplementary list for motion as first item 18.
May please, Your Lordship. This is the eviction matter of Sarkari bill, Lordship.
Hmm.
What happened, Lordship? The petitioner's house is the outside of the mark, the surveyed for eviction by the authority. But on 3rd, Lordship, 3rd of September, the authority went there and one person is already evicted, Lordship. I have annexed one photograph, Lordship. Your Lordship may kindly see annexed.
Yes, what is your instruction? All right. Had Miss
B. Talukdar.
E. Talukdar, learned counsel appearing for the petitioner. The petitioner hearing claims to be in possession of a ceiling surplus land measuring 1 kata 10 acres. Covered by Dag numbers 344 of Revenue Village, Pathar Quarry under Beltola Moja, falling under Dispute Revenue Circle in the district of Kamrup. According to the petitioner, the land occupied by her, the plot of land is being occupied by her since the year 1989 by paying all revenue, including necessary taxes as per law. Full stop. The petitioner also claims to have submitted online application for settlement of the land in her name under the project Hohari, XOHARI, unquote, quote Hohari, which is under consideration before the authorities. Notwithstanding the same, and despite the fact that her land falls outside the earmarked territory of Sarkari bill, respondents are threatening to evict her from the plot of land, that too without serving any prior notice. Full stop. Ms. G. Hazarika, learned Standing Counsel, Revenue Department, Assam, and as Mr. S. Bora,
Correspondent number 3 GMD.
Standing Counsel GMD have prayed for some time to seek instruction in the matter. In view of the above issue, notice of motion returnable on 3rd October 2023. Since Ms. Hazarika has appeared and accepted notice for respondent number 1, Mr. Who else is for whom?
I am for respondent number 3 GMD.
You are for respondent numbers? 1. Ms. S. Borua, learned Government Advocate Assam, for respondent numbers 2 and 4, and Mr. S. Bora for respondent number 3. Service of notice is deemed to be complete in this case. Extra copies of the writ petition be furnished to the learned departmental counsel so as to enable them to obtain instruction. Heard on the prayer of interim relief, having regard to the peculiar facts and circumstances of the case, it is hereby provided that the respondent shall not evict the petitioner from the plot of land under her possession without serving prior notice in writing upon her. Let this matter be listed again by reflecting the name of the petition respondent's counsel in the cause list.
Daily list for motion item 1.
May it please your lordships. My lord, on 16/6/2023, 7 resolutions were adopted by the board of a society by the resolution number 1, his secretary was removed. And by the third resolution, the petitioner number 3 was appointed as a secretary. This is admitted fact. On 27/6/2023, 2 communications were issued which are under challenge in this writ petition by the assistant registrar. By the, my lord, so far as the 27/6, the first one at page 22, there was direction to conduct an inquiry.
What is the order dated 38/2023?
My lord is referring to,
He repealed the file before the authority is allowed, my lord. He got everything, my lord.
that is not perhaps the correct picture. May I present my case? My lord?
No, you come to order, last order of 31st of August. You have a copy of the order.
31st of August, yes. Yes, I have.
Please read that order.
It says that the board resolution of 57/2023 was rejected. This concerns the petition number 1 and 2. There was a move by the board holding a meeting on 57/2023 to take action against the chairman and the vice chairman, the first and the second petitioners hearing. That matter was decided in the appeal and that is gone.
Hmm.
Now the other part remains, the 3 orders, which I'm placing here.
Other part is pertaining to petitioner numbers 1 and 2.
3.
I'll not entertain this writ petition. This is the
Lordship.
misjoinder of cause of action. You have to file afresh. Different petitioners having different grievance
At
cannot be clubbed in.
At the time when the writ petition was filed,
Hmm.
this was not the situation, my lord.
Then you withdraw with liberty to file. For the grievance of number 1 and 2 has been redressed. You can't pursue the grievance of petitioner number 3. alone.
Actually, that is the matter, because by that time it is redressed.
Mr. S. Banik,
No,
learned
wait, wait,
counsel for the writ petitioners submits that during the pendency of this writ petition, the Register of Cooperative Societies has issued order dated 38/2023, by means of which the grievance of the petitioner numbers 1 and 2 in this writ petition has been redressed. However, according to Mr. Banik, the petitioner number 3 continues to be aggrieved in the matter. Mr. T.J. Mahanta, learned senior counsel for appearing for the respondent numbers.
7.
S. Talukdar, learned
Yes, sir.
standing counsel, Corporation Department, Assam, appearing for the official respondents, have submitted that if that be the case, the writ petition would not be maintainable in the present.
Present.
Similar to the stand of Mr. A.B.T. Hawk, learned counsel, appearing for respondent number 6. Miss S. Borua, learned government advocate, Assam, is present on behalf of respondent number 5. In view of the submission made at the bar, this writ petition stands closed by granting liberty to the respondent number 3 to file
Petition number 3.
petitioner number 3 to file a fresh writ petition by agitating his grievance in the matter, if any. Is there any interim order?
No.
Judgment. Must. No, not
Writ
even if
petition
he
stands
is-
in court of.
Item 2.
May I please the court, your lordship? Lordship, the petitioner company is a registered dealer under the Assam Value Added Tax 2003. Lordship, we had paid certain excess amount by way of TDS taxes. Lordship, the tax authorities thereafter conducted audit assessment. Lordship, may kindly come to page number 9.
No, what is your matter first?
Lordship, the TDS amount that the assessment was made, we have not been paid that amount. Although for one financial year we have been paid, but for the rest of the financial years, we have not yet been paid. Lordship, may kindly come to page number 9.
Wait a minute. You have not been paid. Who is supposed to pay you?
Lordship, the authorities,
Authorities are
authorities.
paying
the TDS amount, the excess TDS amount.
the.
They had assessed that we are eligible for refund.
You mean refund?
Yes, your lordship.
Why are you saying pay?
So refund, lordship.
Lordship, notice may go at this because he is claiming refund for 4-5 financial year, Lordship.
We'll
Lordship, along
issue
with
notice and this is heard Mr. B. Mitra, is it?
Yes, Mitra.
S. Mitra and counsel appearing for the writ petitioner. The grievance of the petitioner in this case is that despite repeated requests made by it, the refund of excess TDS amount deducted from the account of the petitioner has not been refunded till today. Mr. B. Chaudhary, learned standing counsels,
Finance and tax.
Finance and Taxation Department, Assam, 6, time to obtain instruction and file affidavit. NOM 8 weeks since Mr. Chaudhary has appeared and accepted notice for all the respondents, no formal notice, extra copy, etc. Let me find.
Item 3.
May I please, Your Lordship? Lordship, this matter may be passed over for time being, Your Lordship. My senior is coming, Your Lordship.
What is the matter about?
Relating to acquisition of land.
Hmm.
We have received
The
the
writ
instruction.
petition is filed against the order dated, impugn order dated 8/7/2023. Annexure 18, page 58, Lordship.
Yes, please read the order.
Acquisition for land. Petitioner yet not get the compensation.
What is the problem with the order?
Lordship,
What is the problem with the order?
they rejected the award. Compensation.
Where is it? Which part?
Page 59, paragraph 4. And kindly see, Lordship, the last order.
So the prayer of request of your clients for payment of compensation has been turned down.
Lordship.
So we'll issue notice. Why it should wait for your
Lordship,
senior?
Last occasion, Lordship was directed to obtain instruction with that regard, Lordship. We have received the instruction, Lordship. It's with my senior, Lordship. He's coming, Your Lordship.
File it in affidavit.
Lordship.
All right, heard, Mr. Your name, please?
A Buragohai.
A. Buragoy, learned counsel appearing for the writ petitioners. The petitioners have approached this court jointly by filing this writ petition, assailing the order dated
8/7.
8/7/2023, issued by the general manager, bracket P, bracket close, NHIDCL, comma, PMU dash Dibrugarh. That is the respond number 3 herein, rejecting the claim for payment of compensation for the land acquired by the NHIDCL, which is claimed by the writ petitioners. Full stop. Mr. Buragoy submits that the claim of the petitioners have been rejected in an arbitrary and illegal manner. Hence this writ petition. I'll record your senior's name.
Lordship.
Mr. C. Borua, Learned Standing Counsel, NHIDCL, is present and submits that he has received instruction and hence, comma, be granted 4 weeks time to place the same on record in the form of an affidavit. In view of the above, issue notice of motion returnable in 8 weeks. Since Miss who is for 1 CGC? Since Mr. H. Gupta, Learned CGC, has appeared and accepted notice for respond number 1. Mr. C. Borua for respond numbers 2, 3.
NHIDCL, Lordship.
Who is for 2?
No, no.
H. Gupta for 1 and 2. Mr. C. Borua for respond number 3. Miss G. Hazarika, Learned Standing Counsel, Revenue Department, Assam, for respond number 4. And Miss S. Borua, Learned Government Advocate, Assam, for respond numbers 5, 6, and 7. Service of notice is deemed to be complete in this case. Extra copies of the writ petition, comma, requisite in numbers, comma, be furnished to the Learned Department Counsel so as to enable them to obtain instruction and file affidavit. Let the matter be listed after 8 weeks for admission by reflecting the name of Learned Counsel for all the parties in the cause list. The parties to exchange pleadings in the meantime. Parties to exchange pleadings in the meantime.
Obliged, must oblige.
Item 4.
My lord,
In other cases, my lord, involving same issue, lordship, notice has been issued, lordship. Issue is lordship in 1959, lordship. Land was allotted to the petitioner's father, lordship. Again, my lord, in 2015, lordship, a proposal was submitted for allotment to the, my lord, their descendants, the petitioner's lordship. My lord, that is 100% premium is to be paid. My lord, challenging the fixation of premium lordship. The writ petition is filed in other case is my lord 4181, my lord, in that case is not.
Where is the order of fixation of premium?
Page 57, lordship. Yes, 57, lordship. 34 lakhs per vigya, my lord.
All right, take down, heard Mr. M.H. Ahmed, learned counsel for the writ petitioners, assailing the communication dated, this is of 2015,
Lordship, but yet, my lord, it is not finalized, lordship.
communication dated 13/8/2015, bracket annexure 13, numerical 13, bracket close, whereby the premium for the land in question has been fixed at rupees 34 lakhs per bigha. The instant writ petition has been filed inter alia contending that the amount is exorbitant and without any valid basis. Mr. Ahmed submits that similar writ petitions being WPC number
4181 of 2023.
4181 of 2023 is pending disposal before this court. First up, in view of the above, issue notice of motion returnable in 6 weeks since Ms. S. Borwa, learned government advocate Assam has appeared and accepted notice for respond numbers 1, 4, 5, 6, and 7, and Ms. G. Hazarika, learned SC, Revenue Department, Assam, for respond numbers 2 and 3. Service of notice is deemed to be complete in this case. Extra copies of the writ petition be furnished to the learned departmental council so as to enable them to obtain instruction and file affidavit. List this case along with WPC.
Item 5.
5 is also, my lord, similar, lordship. My
Date
lord,
of,
impone is at plus 58.
let us see. October 2015,
Lost.
order. Rest will be same.
Or like
Item 6.
May it please your lordship. Lordship, the petitioner is a owner of a plot of land and a some type house there, which he rented out to somebody, and that person started a business of dhaba. There was a complaint that there was some illegal activities going on, and the dhaba was sealed by the district magistrate. Thereafter, there was an inquiry, and it was found in the inquiry that I was the real owner and I have rented it out. In the meantime, 1 year has passed, the tenancy agreement has also elapsed, and I have clearly stated that I don't want to continue the tenancy with him. I have prayed before the authorities to hand over the dhaba to me, the premises to me, as I am the real owner of the plot of land. That representation is also pending, and 1 year nothing has been done.
This is a civil dispute. You should go to civil court.
Between me and the private party, your lordship. But I have also approached the authorities, your lordship, with a representation as well that I am the real owner. That is also evident.
Authorities can't do anything about it. Authority, which authority you have approached?
The district magistrate.
District magistrate has no jurisdiction in this
It
matter.
is put under.
Can you decide who is the real owner?
Not regarding the real owner, your lordship. That is also there, your lordship. Lordship may peruse the report, inquiry report at page 19.
All right, you argue, but at the end of the day, you tell me whether you want to withdraw or I should dismiss. These are matters which should go to civil court.
Lordship, at page 19, once, your lordship.
All right.
After the premises was put under lock and key, there was an inquiry by the executive magistrate. The executive magistrate conducted a thorough inquiry, and may I read, with reference to the subject cited above, I have the honor to submit that the inquiry report of so-and-so at so-and-so, the dhaba is situated at village so-and-so under so-and-so revenue circle, and the land is recorded in the name of Virendra Kumar Das, son of so-and-so. The dhaba has been functioning from October 2022 with a rent agreement between Virendra Kumar Das and the dhaba owner Moon Deka, son of Ramesh Deka, so-and-so. There are cash counters, 6 number of so-and-so. This was found by the executive magistrate in the inquiry.
So you want to evict your tenant?
I want to evict my, in fact, your lordship, after this, my tenant has also submitted a letter to the authorities, page 22, your lordship. He has stated that since he cannot pay the rent to me and the electricity charges are also overdue, I have also informed him through a notice. He
No,
cannot,
what I'm asking is, what is the order you are seeking here?
at this stage, if your lordship pleases, just my representation which I have submitted, if it may be considered, your lordship, by the authorities at an
What is
early
the
date.
representation?
At an early date. It is, I want to evict my tenant, but the physical possession should be handed over to me.
That is what I'm saying. These are matters for the civil court. What has the deputy commissioner got?
Tenants,
Under which provision of law the Dhaba has been sealed?
133 CRPC.
Huh?
133. If
Was
I
there a
go to
proceeding?
that as well,
Was there a proceeding initiated?
after the report was submitted and nothing has been conducted after that.
Is there an order of sealing the Dhaba?
Yes, your lordship.
Where is it?
Page 18.
So, Mr. Mukherjee, you must go to the civil court for evicting your tenant. That's all.
The tenant has.
You are not the owner of the Dhaba.
No, lordship. The
They will
tenant has
proceed.
already written to me that he does not want to continue.
That doesn't matter. Let him vacate it then.
He cannot because it is under lock and key, your lordship. He wants to vacate it, but as it is sealed by the authorities, no one can enter there, your lordship. That is the main issue. Until and unless the seal is removed, no physical possession.
Then you ask for modification of this order.
The order is not directly against me. I have also challenged this order in this writ petition, your lordship, because under 133, the provisions quoted.
All right, we'll issue notice, hear it in due
Lordship,
course.
if a short
Because
date,
you
your
are-
lordship.
huh?
Because I am losing on tenant rental income from the.
No, why don't you ask for modification of this order?
I have prayed before this honorable court for cancellation of this order as well, your lordship.
No, but these things can't be done on representation. You have to. Yes, what is your instruction?
Instruction, lordship, but this is a purely civil dispute, lordship. And
No, what is sealing of Dhaba by district administration? How is it a civil dispute? What is the civil dispute here? No, he says he is the owner of the premise and the tenant was to vacate it. But because of the order sealing it, he is not being able to do so. What is your response to that? You obtain instruction, then we'll keep it on motion. Or
that
Mr.
instruction will be obtained by government advocate, lordship. I am appearing for only as one number 1.
You decide who wants to
Lordship.
appear.
Lordship.
Mr. B.J. Mukherjee, learned counsel appearing for the writ petitioner. The only grievance of the petitioner is to the effect that his tenant, who was earlier operating the Dhaba, wants to vacate the same, vacate the tenanted premises, which is owned by the petitioner. First of, however, due to the order dated 21/10/2022, by means of which the Dhaba was sealed, the tenant is unable to take back his property so as to vacate the Dhaba. Full stop. Mr. Mukherjee further submits that he is merely the landlord of the premises and has got nothing to do with any activities carried out therein whatsoever by his tenant. Full stop. Ms. S. Borua, learned government advocate Assam, raised for 10 days time to obtain instruction from the Deputy Commissioner Bongaigaon responding.
Is not a party in this matter.
District magistrate.
District magistrate and executive magistrate.
For district magistrate, high court.
District Magistrate, who is the District Magistrate nowadays?
It was signed by the district magistrate. The order was passed by the district magistrate.
Yes, but after that, it has now been changed into District Commissioner.
District magistrate is an authority under the CRPC, Your Lordship. District commissioner.
You are trying hard to ensure that your client gets stuck up here for few years, Mr. Mukherjee. Obtain instruction from the concerned authorities if they are implicated as party in this writ petition. 2 extra copies of the writ petition be furnished. If there is no district magistrate, don't obtain any instruction. As simple as that. He is stubborn. He doesn't want to implicate the district commissioner. And there is no district magistrate. So next day you say that there is no authority. We'll issue rule and you hear it in due course.
We have not received any copy, Lordship.
Yeah, 2 extra copies, yes.
And our name also reflected.
Let this matter be listed again by showing the name of Miss S. Borua, Learned Government Advocate Assam. CRPC was framed when?
73, yeah.
Which year?
1973.
Some changes have happened recently. You were there, no?
That is.
You know the changes.
Yes, Your Lordship.
District magistrate is no longer in existence. You do it at your own peril. Yes, next matter.
Item 7.
May I plead your lordship? Lordship, the petitioner was functioning as a ex-president of 241 Nang Bhatia Kaligao Panchayat in the district of Nagaon. The petitioner received only 17 months remuneration as a PRIS representative. Now she is entitled to get 43 months remuneration.
This is a bench, civil bench 3 matter, remuneration.
Remuneration to
Similar-
elected members, my lord.
Is it
Yes, yes.
Similar
a this
matter,
bench?
Yes.
lordship, similar matter already considered by this honorable
We'll issue notice then at this stage. Heard, Mr.
M. Hussain, lordship.
M. Hussain, learned counsel appearing for the petitioner. The writ petitioner herein is the former resident of number 41. Bhatia Khali
241, no?
Gaon Panchayat. 241 Bhatia Khali Gaon Panchayat in the district of Nagaon, Assam. She has approached this court by filing the writ petition, inter alia alleging that her remuneration due and payable under the law for a period of 17 months has not been paid till today without any valid reason. Full stop. Mr. S. Datta, Learned Standing Counsel, PNRD Department, Assam, as well as Mr. H. Chalia, Learned Standing Counsel, Finance Department, Assam, have prayed for some time to obtain instruction in the matter. Issue notice of motion returnable in 4 weeks since Mr. Datta has accepted notice for respond numbers
1, 3, 5, 6, and 7.
5, 6, and 7. Mr. A. Chalia for respond number 2 and Mr. S. Borua, Learned Government Advocate Assam for respond number 4. Service of notice is deemed to be complete in this case. Extra copies of the writ petition be furnished to the Learned Departmental Council within 3 days from today. Taking note of the submission of petitioner's counsel to the effect that similar matters have already been disposed of by this court by issuing a writ of mandamus, the departmental council are directed to obtain instruction facilitating disposal of the writ petition at this stage of admission here.
May I submit on that point, my lord? In that case, my lord, only pending
Do it on the next
remuneration,
day, Next day,
my lord.
yes.
Item 8.
May it please your lordship. Well, at earlier occasion, I came before your lordship, and your lordship passed the order to approach before the deputy commissioner. My lord. So we approached the deputy commissioner and filed a representation, my lord. Your lordship's order.
Page 145.
Is page 145, my lord.
Page 145. Yes. Yes, what has happened?
Now, my lord, representation, we have filed, my lord, at 148, my lord, to the Commissioner Dorong District.
Mhm. Yes,
Another representation, my lord, at page 223, Commissioner Morigaon District. Now, my lord, case is like this, my lord. These are our Patra land, my lord.
so what happened to the representations?
That representation is not addressed, my lord. They want to say, my lord, what is our information? They want to say that the land has been taken by the union government, by forest department. We cannot do anything.
My lord, my specific instruction today is that, my lord, after this order, there was a meeting between Honorable Chief Minister and the concerned deputy commissioners yesterday. And Honorable Chief Minister has directed them to allow harvesting of jute, my lord, that for which they have come before this honorable court. So they will be called within a day or two, along with other cultivators, and they'll be allowed to go for harvesting.
My lord. And in that case, my lord, regarding jute cultivation is all right, my lord. Now, second question.
Mr. Sheikh, I think you should now rest.
No, my lord, regarding jute cultivation, I am satisfied with my learned friend's direction, my lord. Now, my lord, your lordship would be pleased to see we have patta on the land from 1929 onwards, my lord. 1929, 1930, 33, 35, and we are giving revenue on the land. Now, what happened, my lord? On a fine morning, they have demolished our houses from the patta land, my lord, and taken away the land. Now they are not allowed to enter into the land, and the jute cultivation part is over. Now what happened, my lord? Under this act, my lord, right
This
to
was the
fair
same prayer.
compensation.
This was the same prayer along
My
with.
lord, no.
Let him finish.
Let me finish, my lord. Under right of fair compensation, my lord, we are entitled to compensation, provided, my lord, if the land is required for public purposes, they can acquire the land. We have no objection. They want to say for extension of that reserve, tiger reserve, this land is required. But we did not given any notice. Under the right of fair compensation, my lord, we are entitled to notice. Our patta land is taken. In that case, notice is to be given. If we have some objection, my lord, they have to address that objection. And after hearing, government can take it that it is for public purpose, land is required. But we are entitled to rehabilitation. That is also the provision, my lord, right to fair compensation and transparency in land acquisition and rehabilitation and resettlement act 2023, my lord, 13, my lord. Your lordship now would be just
Right,
for
Mr.
your,
Sheikh,
for your lordship satisfaction,
Mr.
my lord.
Sheikh, please,
I want to place before your
please
lordship the
listen to
patta,
what I'm saying.
my lord.
If patta land of the petitioners or any of the petitioner has been taken away
My lord,
without following the due process of law,
due
then
process of law,
the matter will certainly be examined by the
my
court.
lord.
But for now, let us postpone it by 10 days by taking note of the submission of Mr. Goswami.
Yes,
that
my lord.
your clients will be allowed to cultivate the jute,
Harvest the.
harvest the jute.
Yes, my
Right.
lord.
So I'm posting it after 10 days
My lord,
for him to get updated instruction.
my lord.
But I will also record an undertaking that for now, your clients will vacate the land soon after the harvesting.
We are not in the land, my lord. We are already evicted.
No, to harvest it, you will have to enter the land.
My lord.
So
Yes.
I'm recording your categorical submission that
Hmm.
as soon as the harvesting is over, the petitioners will vacate the land, abiding by further order as
Yes,
may be
yes,
passed.
definitely, my lord.
Right?
Yes, my
So we'll post it after 2 weeks for motion,
my lord.
and then we'll see what are the other issues.
My lord, may I pray that my learned friend also be pleased, subject to your lordship's direction, that instruction regarding this land, whether our land is patta land, whether any
So
compensation.
that will happen only when notice is issued.
My lord, there are 72 petitioners, my lord.
The court is not yet issuing
My
notice
lord,
today.
my lord.
We'll see, we'll look into it.
Yes, my lord.
Your grievances will be looked into.
Yes, my lord.
But how we'll do it, we will decide, not you.
My lord.
So you
Yes,
wait
ma'am.
for 2 weeks.
Yes, my lord.
I'm postponing it for 2 weeks for motion for updated instruction.
My lord.
Thereafter, we'll issue
My lord.
notice.
Regarding, my lord, just a 1 minute, my lord.
Yes.
Regarding their claim of, my lord, compensation, Most of these lands were erosion affected. Most of the petitioners were rehabilitated somewhere else. These are their old lands, my
So you
lord.
file your affidavit.
That's
then
why
we'll
there are
see.
73 petitioners. Everybody has different story.
They have their version, you have your version.
My
The
lord.
court will have to give a finding. We can't do it
Execute.
overnight. But at the moment, the burning issue
harvesting,
is
yes.
harvesting.
Yes.
So let us focus on it.
My lord.
Otherwise, too many issues and it will get mixed up. Take down. I heard Mr. M.A. Sheikh, Learned Counsel appearing for the writ petitioners, who submits that in terms of the earlier order dated
Here's
38
145, my lord.
38, 2023, passed by this court in WPC number 4916 of 2023, instituted by the present writ petitioners. Two separate representations have been submitted on 31/8/2023 before the district commissioners of Darang and Morigao. Is it?
Darang and Morigao.
Darang and Morigao, requesting the authorities to permit the petitioners to harvest the jute cultivated by them over the plot of land in question. However, till date, no response has been. The said representations have failed to evoke any response. As such, the petitioners have been compelled to rush to the court by filing the present writ petition. Mr. P. N. Goswami, Learned Additional AG, Assam, appearing for the official respondent, submits that a decision has been taken to permit the petitioners to harvest the jute cultivated by them, and they would soon be called for a meeting by the concerned deputy commissioners for giving effect to such decision. On such ground, Mr. Goswami has sought posting of this matter for motion again after 2 weeks. Full stop. Although there are other issues raised by the petitioners in the writ petition, yet this court is conscious of the fact that the immediate concern is pertaining to the issue of harvesting of jute as the produce, as the crop faces imminent danger of being destroyed by natural process. As such, without making any further comment on the submissions made by the Learned Counsel for the parties, this writ petition is being directed to be posted again for motion after 10 days, so as to enable Mr. Goswami to obtain updated instructions in writing and place the same before the court. On the question of harvesting of jute, it is made clear that the undertaking given by Mr. Sheikh that if permitted, his clients would carry out the harvest as expeditiously as possible and thereafter would vacate the land in question, abiding further order of this court would be implemented strictly by both the parties. Let this
Harvesting,
matter
my
be
learned
proceeded.
friend, my learned friend said that within 2-3 days, at least or within 1 week, my lord, not more than that. That may be.
All right. Have some sense of balance. You are an officer of the court. You are not going to go and harvest. You understand how the system works. Don't
Obliged.
stretch it beyond a limit. Huh?
Obliged.
Everybody is doing their job. Yes.
Item 9.
Much obliged.
Please, your lordship.
Yes.
My lord, the petitioner is the principal of a training institute, my lord. By Annexure A, page 12, your lordship may kindly see page 12, my lord. She was entrusted with the task of training students belonging to scheduled caste community, my lord, 30 numbers of students, and she was paid 50% advance. At page 12, I'm reading, my lord. Therefore, you are requested to admit trainees after receiving 50% advance of the payment as prescribed rates. Accordingly, my lord, training was completed, my lord, and the petitioner submitted her bill, and the representations are also pending before the authorities, my lord. I have annexed, my lord, but the 50% have not been paid, remaining, my lord, 1,80,000.
So this is
And-
non-payment of what, bills?
Yes, my lord.
Is this a civil bench 5 matter? Non-payment of bill is not pertaining to this. Is it? All right, we'll issue notice, but ask the registry to verify whether it is. Oh,
Maybe bench 4.
all right, heard Miss S.B. Chaudhary, Learned Counsel appearing for the writ petitioner. The petitioner is aggrieved by non-payment of 50% of the fees for carrying out training of youths belonging to scheduled caste community. Under the instructions of Director of Employment and Craftsmen, under the instruction allotted to the petitioner by the Director of Employment and Craftsmen Training, Assam. Despite bills have been submitted to that effect, Mr. S. Barua, Learned Government Advocate, Assam, prays for some time to obtain instruction in the matter. NOM 6 weeks since Mr. Barua has accepted notice for all the respondents.
For
No
one
problem.
and three.
Actually, 1 and 3, and Mr. Who is for 2?
Two notice has to go in.
1 and 3, as such, no formal notice is required to be sent to said respondent. Petitioner to furnish extra copies of the writ petition to the Learned Government Advocate, Assam. Steps by registered post with AD for service of notice upon respondent number 2 by registered post. Within a week from today, let this matter be listed again after 6 weeks, no? On verification whether this matter pertains to civil bench file or not.
Item 10.
May please your lordship. My lord, the petitioner before lordship, they are facing an eviction notice, my lord, annexer at page 81, my lord. They are residing through their forefathers for more than 60 to 70 years, my lord. My lord, my lord, the eviction notice has been issued followed by an order in the PIL, my lord. Against that PIL, my lord, there is an SLP, my lord. In the SLP, my lord, the Supreme Court says that before taking the recourse of eviction, they will give their claim may be examined by the concerned deputy commissioner. If the decision should be taken, if the decision is an adversarial, then they will be also given an opportunity to approach the appropriate forum. And in that light, my lord, this honorable court has passed similar order, annexer 16, my lord. My lord, relevant paragraph, my lord, paragraph 8 and 9, my lord. Page 118. The order of this honorable court passed in a similar case, my lord. Paragraph 8 and 9. My lord. My lord. Yes, my lord.
Maybe dispose of my book.
Can be disposed of.
Petition direction.
So where is the order of the division bench and where is the order of? the
My lord,
Supreme Court?
order of the division bench I have also annexed, my lord.
Page number?
My lord. My lord. My lord, at page 76. my lord. Yeah. 78/2012.
And Supreme Court order?
My lord, at page 115. %, at page 116.
So you are in occupation of government land,
My lord,
Sarkari
the
land.
khas land, my lord, government khas land, not one.
So no objection if it is disposed of.
No.
You are appearing for whom?
BTC. Respondent number.
Respondent.
3, 4, 5, 4, and 8.
Take down. Heard Mr. A.R. Sikdar, learned counsel appearing for the petitioners. Also heard Mr.
Arkim, sir.
We'll record your names also. Also heard Ms. G. Hazarika, learned standing counsel, Revenue Department, Assam. Appearing for respond number 1. Mr. S. Borua,
6 and 7.
learned Government Advocate, Assam, appearing for respond number 6, 7 and 8. Why not? 6 and 7. And Mr.
Arkim, sorry.
R.K. Mushari, learned SC BTC, appearing for respond numbers
3, 4, 5, and 8.
5 and 8. Full stop. None has appeared for the respond number 2. Full stop. The writ petitioners herein are admittedly in occupation of Sarkari land situated within the Buxa district falling under the BTC area. First stop. Apprehending eviction from the land under their occupation, the petitioners have approached this court seeking an order of protection in the line of the direction issued by the Honorable Supreme Court in the case of special leave petition. Now, in SLP number 2121/2020, 2020, dated 03/02/2020, arising out of judgment and order dated 9/12/2019, passed by the division bench of this court in PIL number 78/2012. Mr. Sikdar submits that the present move to evict the petitioners is apparently in terms of the direction issued by the division bench on 09/12/2019 in PIL number 78/2012. Full stop. However, Mr. Sikdar submits that in the SLP preferred against the order dated 9/12/2019, the Honorable Supreme Court has clearly provided that the claims, if any, of the occupant of the lands be examined by the concerned Deputy Commissioner on case-to-case basis after recording satisfaction in the light of the evidence produced before him by the proceedee. whereafter appropriate order was required to be passed as per law. Full stop. Mr. Sikdar submits that following the observations made by the Supreme Court, a number of writ petitions have been disposed of by the learned single judge, issuing a direction upon the concerned authority to examine the evidence, if any, submitted by the proceeding on receipt of notice so as to establish their claim over the land. Full stop. In support of his above contention, Mr. Sikdar has produced a copy of the order dated 17/8/2023 passed by the learned single judge in WPC number 4724/2023. I have perused the same. Mr. Musahari has submitted in his usual fairness that he would have no objection if the writ petition. Now, I have perused the same, full stop. From the above order, it appears that the learned single judge has granted liberty to the writ petitioners in the said proceeding to submit relevant documents pertaining to their claims over the land under their possession before the concerned deputy commissioner, who has further been directed to examine the same and pass appropriate order thereupon. Full stop. Then you write, Mr. Mushahari, learned SC BTC, has submitted in his usual fairness that he would have no objection if the present writ petition is also disposed of with a direction of similar nature. In view of the above and considering the materials placed on record, this court is of the opinion that a similar view is required to be adopted in the present petition as well. As such, the instant writ petition is also disposed of by granting 4 weeks' time to the petitioners to submit individual representations along with supporting documents before the district commissioner Baksa in support of legitimacy of their possession over the land under their occupation. Full stop. If such representation along with supporting document is submitted by the petition individually within 4 weeks from today, he saved the exam, on case-to-case basis, and thereafter the concerned district commissioner may pass appropriate orders in the matter in accordance with law. Full stop. Until such time the aforesaid exercise is completed, status quo as regards the possession of the petitioners in respect of the land under their occupation shall be maintained. Writ petition stands disposed of.
Item 11.
Lordship. Lordship, the petitioners are own sister lordship, and after their marriage, they used to live in Guwahati lordship. Lordship, on 15/1/2023, one Halim Ahmed Chaudhary, taking a big group lordship, entered into the ancestral house of the petitioner lordship, which is situated at Chilsor lordship, and demolished their house lordship. On the result, the petitioners filed 3 FIRs separately lordship, dated 16/1/2023, 21/2023, and 11/3/2023. But the police has not taken any action yet, lordship. At this stage, I am paying for only no issue notice, lordship.
Your name, please?
Ahmed Soikia, lordship.
Mr. Ahmed Soikia, learned counsel appearing for the writ petitioner, peruse the amendments made in the writ petition. Mr. N. Goswami, learned government advocate, Assam, submits that some time be granted to seek instruction from the officer in charge of Rangirkari town outpost with regard to the progress made in investigation in connection with Silchar PS case number 327/2023, registered under section 448/427/379 of the IPC. In view of the above, issue notice of motion returned within 4 weeks. Since Mr. Goswami has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copy of the writ petition be furnished to the London Departmental Council so as to enable him to approve the public.
Item 12.
Please, Your Lordship. This case is relating to scholarship of the petitioners, Your Lordship. Petitioner qualified for the scholarship exam, Your Lordships. He has appeared, she has appeared, and
Why scholarship?
Department.
This is the education department matter.
education, but
This is
listed
civil bench
before-
2 case.
before you.
Let it go there. All right. I heard Mr. R.M. Chaudhary and counsel for the petitioner. Whereas the amendments made in the writ petition, it prima facie appears that this matter pertains to civil bench 3. Miss
S. Kumar.
S. Cole under SC Education Department, bracket elementary, bracket close, also supports the said view. As such, register to verify and list this matter before appropriate bench in the next week. Next week?
My lord.
Item 13.
May I please, Your Lordship? My lord, recently the Honorable Supreme Court passed a decision in IA directing the the Central Register of Minister of Cooperation to release the the Shara companies investor, my lord. One of these Shara group of companies investor, my lord. Accordingly, my lord, in terms of the direction, my lord, I submitted a representation to the my lord ministry to release the invested money, but that is yet to be my lord considered. So, my lord, at this instance, my lord, notice may be issued to the my lord, particularly the respondent number 2 here. Is the my lord Central Register of Cooperative Societies, my lord, New Delhi is the
Will issue notice. Heard Mr. M.I. Islam, Learned Counsel for the writ petitioner. Full stop. The petitioner herein claims to be an investor in the assets of Sahara Credit Cooperative Society Limited, aggrieved by the inaction of the respondent number 2 in his failure to take proper steps for releasing the maturity value of the investment made by the petitioner. The instant writ petition has been filed seeking a writ of mandamus. First up, I have perused the amendments made in the writ petition. You are appearing for?
Respondent number 1, Your Lordship.
Mr.
DJ Das, Your
DJ Das, Learned Standing Counsel, Learned CGC, appearing for the respondent number 1, prays for some time to obtain instruction in the matter. In view of the above, NOM 6 weeks, since Mr. Das has accepted notice for respondent number 1, and no formal notice is required to be sent to the said respondent. Extra copies of the writ petition will be furnished to Mr. Das. Petitioner to take steps for service of notice upon respondent numbers 2, 3, and 4 by registered post with AD within a week from.
my lord, a similar writ petition is also pending. So
Let this writ petition be listed along with WPC number
4183/23.
4183 of 2020.
All right.
Supplementary rate for motion, item 19.
Please, Your Lordship.
Yes.
May I, Lordship? I am the owner of a land where I have constructed up a semi, it's a tin shed, and it has been constructed in the year 2009. Thereafter, one of the complainant who has no locus in the case came before this court with, and this court has passed an order, and wherever it is stated that I am making construction. And but the construction is old construction, and I was constructed in the year 2009 and 10. And this gives, moreover, after the order of this court, the development authority, without verifying any of the thing and not giving me any opportunity, has passed the order to demolish the same.
Where is the order of the authority?
Order of this court.
Or the order of the development authority?
It is an extra 5 force.
Can you give the page number, please?
Yeah, please, sir. It is annexure number 424, page number.
Yes, who is appearing for the
I'm
respondents?
paying money. This is notice may go, my lord.
All right, your name, please?
M. Laskar. M. Milan Laskar.
Heard Mr. M. Lashkar, learned counsel appearing for the lead petitioner.
Your lordship, may I praise, escape because the electricity department has been directed to cut the kindly stay of this portion.
Assailing the speaking order dated
Copy DNS.
3/4. This is order dated 3/4/2023.
Please, Your Honor.
But the court's order was passed on
2022.
Yes. 3/4/2023, issued by the chairman of the Silchar Development Authority, Silchar. That is the respondent number. Okay, you have not made him a party.
I have made it. I have
Okay,
made it.
respondent number 3.
He is at respondent.
Directing.
He is respondent number 5, and the real owner is respondent number 4.
No. Chairman, Silchar Development.
Yes, he is respondent number 3.
Respondent number 3, issuing an order for demolition of the petitioner's building. The instant writ petition has been filed. Mr. Lashkar submits that the speaking order dated 3/4/2023 has apparently been issued in compliance with the order dated 15/6/2022 passed by this court in WPC number 3910 of 2022. However, in doing so, the concerned authority neither verified the real facts nor was an opportunity of being heard being given to the present petitioner, who is the actual owner of the land and the building. According to Mr. Lashkar,
Please,
the building constructed by the petitioner is an old building, and therefore the allegations made by the private respondent, you have implemented in private respondent?
Yes. He is at respondent number 5.
Respondent number 5, who is a stranger to the controversy, was wholly unfounded and hence called for proper verification, proper factual verification after giving an opportunity of being heard to the petitioner, which was not done in this case. Mr. Lashkar has also prayed for an interim order suspending the operation of the impugn order dated 3/4/2023 by urging that instructions have already been issued for disconnection of power supply to the petitioner's premise. Ms. S. Tutia, learned, you are for which?
I am appearing for only respondent number 1, my lord.
You are standing counsel.
No, my lord, I am appearing on behalf of P. Nayak. He is standing counsel. P. Nayak, my lord.
Then I'll record his name.
My lord.
Mr. P. Nayak, non-standing counsel. Assam Housing and Urban Affairs Department has prayed for 4 weeks' time to obtain instruction in the matter. In view of the above, issue notice of motion returnable in 4 weeks. Since the respondent number 1 is already represented, no form. What about number 2?
Look for number 2, my lord, government is.
Is a development authority.
Respondent number 1 is already represented by Mr. Nayak, and Ms. S. Borua, learned government advocate Assam, has appeared for respondent number. So Mr. Nayak is 1 and 2. huh? Since respondent numbers 1 and 2 are already represented by Mr. Nayak, no formal notice is required to be sent to the said respondent. Extra copies of the petition will be furnished to the learned standing council. Petitioner to take steps for service of notice upon respondent numbers 3, 4, and 5 by registered post with AD within 3 days from today. Heard on the prayer of interim relief, having regard to the facts and circumstances of the case, as well as the allegation made in the writ petition that the petitioner was not heard before the impugned order is issued. As an interim measure, it is hereby provided that operation of the speaking order dated 3/4/2023 shall remain suspended until further orders.
Item 20.
Yes, what is this?
Lord, the action of the IRCTC authorities has Lord created this problem, Lord. Lord, the petitioner number 1 was awarded a contract of license of food plaza at Kolkata, my lord. And as a project loan, Lord, we had taken a loan from the UCO Bank, my lord. And there, the Lord, the plants, machinery, equipments were all hypothecated, my lord. And Lord, even Lord, the petitioner had mortgaged immovable properties. Along with that, my lord, there were 3 LIC policies, my lord. The value was 11.42 lakhs, my lords. Lord, the petitioner has been paying the EMIs till last month, my lord. Only on 29th, my lord, it could not pay. And what happened, my lord? In 2021, my lord, the IRCTC terminated the contract on a purported dispute of additional space, my lord. My lord, we invoke arbitration clause, my lords, and award was issued in our favor to the tune of 1.86 crores, my lords. Plus, for the other part which were not given to us as compensation, my lord, we have moved Delhi High Court, my lord, and we have notice has been issued. The IRCTC authority has filed a belated petition. It is pending, my lord. This time barred. Your lordship knows after 120 days it cannot be entertained. In between, my lord, we had also requested the bank authorities that we'll be getting some amount from the Lord IRCTC authorities, and we have also submitted representation. And Lord, our LIC policies, 3 numbers, Lord, had matured in March 2023, Lord. The value was 26 lakhs, Lord. And we had requested just before the date that they may adjust this amount as regard that installment payment, Lord, so that our NPA does not become, Lord, our account does not become NPA, Lord. That has been rejected by letter dated 29th, my Lord. And against that, we have come before your lordship, my Lord. And Lord, so far as the amount of IRCTC is concerned, Lord, that was as regard the COVID payment, Lord. What has happened during the COVID period, Lord, the entire Lord, licensing was stopped, Lord, and they had taken a policy decision that they would refund 90% of the amount. Subsequently, it was 100% with GST. And license was such, Lord, we had to pay 100% in advance. And that entire amount has come from the bank, Lord. And in fact, Lord, our plants and machineries to the tune of 1.75 crores was, Lord, they have forcefully taken, and they had also submitted an affidavit to. Earlier, they had denied, but during the proceedings, Lord, they had filed an affidavit to the effect that these were in their custody, Lord. Now, because of the inactions, and Lord, now they have awarded the contract, Lord, that we had not challenged because we had sought for compensation. Our license fee was 4.75 lakhs per annum with GST, and they have awarded the contract to a third party for 4 crore for 32 lakhs, causing loss also, my lord. So in these circumstances, we are before your lordships, my lord, that if they, my lord, the bank would have adjusted that amount, my lord, our account would not have become NPA. And my lord, the undisputed amount of 1.86 crores, my lord, if the IRCTC would have paid, my lord, we would have been able to liquidate, my lord, because the operation is closed from, my lord, April 2021. But the petitioner number 1 and 2 are having other company, my lord, from which the continually we have been making payments, my lord. And we have also got licensed premises elsewhere from where we are.
So is this a matter which comes within Article 226?
My lord, because my lord will see the decision of the UCO Bank, which is an authority of declaring the asset as NPA, my lord. In these circumstances, definitely, my lord, your lordship may examine the matter. Because otherwise I have no forum, my lord, so far as declaration of NPA is concerned.
Your lordship, the writ petitioner's account was declared NP on 29/8/2023. And since June 2021, account become irregular. The first reschedulement was given in the month of June 2021, and the second reschedulement was given in the month of December 2022. But both are not followed and terms and conditions are satisfied. So we have already initiated surfacey action. So in the event of this surfacey action on 12/9/2023, I do not think so this writ petition itself is maintainable.
My lord, this-
And
That's
whatever,
the problem, you have to challenge it in the DRT.
my lord, that is a subsequent action, my lord. My lord, if the decision goes, my lord, but the consequences will follow, my lord. And because we have also, my lord, made a prayer against the IRCTC, my lord. Well, let them at least.
These matters can't be entertained. There are Supreme Court judgments. You challenge the notice issued under Surfacey Act.
That I have an independent cause of action, my lord, so far as 13(2) is concerned, my lord. 13(2), my lord, because I cannot.
All right,
challenge-
we'll issue notice, but we'll reject all interim prayer and we'll make
Yes.
it clear that pendency of this writ petition will not be a bar for the authorities to proceed against the petitioner in accordance with law in
Yes.
any other ancillary
yes,
proceeding.
sir.
File your affidavit.
Yes, sir.
Mr. R. Dubey, learned counsel appearing for the writ petitioner. Also heard Mr. M. Sharma, learned standing counsel, UCO Bragg, appearing for the respond numbers
1 and 2.
1 and 2, and Mr. N. Anik Singh, learned SC IRCTC, appearing for respond numbers 3 and 4. The instant writ petition has been filed primarily being aggrieved by the decision of the bank to declare the loan account of the petitioner as non-performing asset, within quote, non-performing asset, bracket NPA. According to Mr. Dubey, the securities pledged with the bank in the form of
Immovable property and movable property.
immovable and movable properties, more particularly the policies of LIC, which had in the meantime matured, ought to have been adjusted by the bank against the installment
Yes, ma'am.
payment to be made by the petitioners, in which event the account would not have turned into NPA. Mr. Sharma, on the other hand, submits that the account of the petitioner has not only been declared as NPA, but action under section 12,
13.
section 13 bracket 2 of the
Surfacey Act.
Surfacey Act has also been initiated. As such, submits Mr. Sharma, the writ petition is not maintainable as the petitioner has adequate alternative remedy provided under this statute. Similar as the stand of Mr. Singh, Land Standing Council IRCT. Responding to the above, Mr. Dubey has prayed that the only issue urged in the writ petition is pertaining to the fairness of action of the bank and not for a stay of any proceeding initiated under the Surfacey Act, contending that there is no other forum available for the petitioner to raise the issue. Mr. Dubey has prayed for issuance of notice of motion in this case. First, after hearing the submissions made by the learned counsel for the parties, I am inclined to issue notice in the matter. NOM 8 weeks. Since the respondents are already represented, no formal notice is required to be sent in this case. Extra copies of the writ petition, requisite in numbers be furnished to the learned standing counsel for the respondents so as to enable them to obtain instruction and file affidavit. It is, however, made clear that pendency of this writ petition shall not be a bar for the bank to proceed against the writ petitioner in accordance with law, if so advised, for recovering the amount found due and pending against him, against it. Full stop. The question of maintainability of the writ petition is also kept pending and shall be gone into at this stage of admission.
One prayer, my lord. My lord will see at page 43, my lord. the hypothetical properties blood against which they also proceed, blood, it is within the custody of IRCT. They blood bank blood
Your
may
Lordship.
take liberty, blood.
The,
At least they.
the simplest order I should have passed here is dismiss your petition. I'm not doing it so that you get a chance to get a little more into the law. That's the only reason. I want you to understand the law a little more. These petitions are not maintainable, as simple as that.
We will try to persuade your lord.
Nothing. You do it. That's why I've kept it alive. Beyond that, you can't get anything. Look at the successive orders of the Supreme Court, judgments of the Supreme Court. You cannot. You cannot. The only forum where you can raise this issue is in the DRT, which is again, the purpose of DRT is not to adjudicate, is to recover. So this is a one-sided affair, and that is the intention of the government, and you knew about it.
Blood, at times,
You have
blood,
to
they
suffer it.
also exceed jurisdictions, blood, and blood. act
We will
beyond.
see when they do it.
Yes, yes.
But today you
my
have
submission-
no cause of action practically.
I'll try to satisfy
But
your lordship.
since you said you want to convince the court, I'm giving you an opportunity,
Keep
nothing
you.
beyond that.
For admission item 14.
Last order, your lordship will send this advance. Your lordship has recorded the entire facts. And we are praying that since the state government has failed to carry on the investigation as per provision of law since 2016, when her petitioner's husband was kidnapped, my lord. Your lordship, 7/8/2023 on.
Where is Mr. R.K. Dev Chaudhary? So it was today posted to have the response of this CBI counsel, but he is not around. Please wait for a little bit. Yes.
Item 15.
This case, your lordship. The case of the petitioner was that, your lordship, he is on occupation of a 5 acres of land, your lordship. Covered by, according to him, doc number 9 of demo grant lot number 2, your lordship, which is a ceiling surplus land, your lordship. And while he was in possession, your lordship, of that plot of land, your lordship, electricity connection was also there for him. And your lordship.
No, just a minute.
Lordship.
Would you please begin from the beginning once
No,
again?
no.
Yes, what is the matter about?
Matter, your lordship, the petitioner was in occupation of a particular land, particular plot of land, 5 acres of land, your lordship.
Hmm.
Covered by, according to him.
What
your
land is this? Sarkari land?
Sarkari land, your lordship,
Yes.
according to him.
Hmm.
Now, your lordship,
He was in possession, your lordship, of that plot of land by this constructing an Assam type house, your lordship. While he is in possession, on page 33, your lordship, if your lordship comes, a notice was issued in his name by the circle officer, your lordship.
Page 33.
33, your lordship. This is the first notice, your lordship. Papon Shah, your lordship. Versus so-and-so. I am Papon Shah. You are asked to remain present in the office of the undersigned so-and-so in connection with the application submitted Anwar Hussain so-and-so in connection with non-payment of rent of a house rented for the purpose of garage and for vacating the premises to the opposite party Papon Shah situated part of plot of land measuring 2 kathas covered by Meadi Patta number so-and-so, so-and-so, your lordship. Now, pursuant to that, your lordship, next, your lordship, an eviction notice was issued, your lordship, page 35, your lordship will get it.
Non-payment of rent, he was required to pay rent to whom?
According to your lordship, the private respondent to Anwar Hussain, your lordship. He is the private respondent number, your lordship, 8, your lordship. 9, 8. 8.
So he had failed to pay rent to private respondent.
Lordship.
That's why the circle officer has issued this notice.
And then your lordship, an eviction notice order was also issued, your lordship, by the circle officer, saying that the plot of land on which I am residing, your lordship, it has already been given as a patta to the, your lordship, the respondent number 8. So he issued an eviction notice, your lordship, that is at page 35. It is hereby informed you that as per record, Patta is running in the name of Anwar Hussain in respect of a plot of land measuring 2 kathas covered by Patta number so-and-so, Dag number 343 of Demo Grant under Thaura Moza. It is informed by the Pattada that you have not been paying rent amount of the Assam type situated in the premises of which you have taken on rent and you are residing upon. After field inquiry by the concerned Latmandal, it has been found that the land which you are residing upon belongs to Muhammad Anwar Hussain. Therefore, for the convenience of the Pattada, you are directed to vacate the land.
Yes, what else then?
Then, your lordship, after that, your lordship, what has happened, your lordship, that the APDCL authorities, your lordship, on the basis of a complaint lodged by them and referring to the field verification made by the circle officer, your lordship, but cancel my, your lordship, the connection, your lordship. Withdrawn the connection, electricity connection. At that point of time, your lordship, I came before this honorable court by challenging these circle officers' report since he has no authority to issue this, and also the order of the direction of the APDCL, your lordship. And the honorable court, your lordship, on the very first date, your lordship, that was by order dated, your lordship will get it, your lordship, on 4/4/2022.
Yes.
Your lordship may come to the operative part, your lordship, at the second page. A specific statement has been made in paragraph number 13 of the writ petition that petitioner has approached the said subdivisional engineer for submitting necessary documents in pursuance to the communication dated so and so, but the subdivisional engineer, who is at the respondent number 7 herein, has refused to accept the same. Taking into account the notice dated 5/2/2022 and a specific statement made in paragraph 13 of this court is the opinion, and accordingly direct that the petitioner may be permitted to submit all his documents in support of his case, on the basis of which the petitioner has taken the new connection, and accordingly the petitioner will submit such documents within a period of 10 days from today. The respondent numbers and
Now, do you have electricity in
electricity already? In the meantime, they have filed a suit, your lordship.
Who has filed the suit?
The respondent number 8, your lordship. This is pending, your lordship.
We'll close it.
Yes, your
Satisfied.
lordship.
Yes, my lord, this matter may be closed by, as per the Supreme Court judgment, electricity is necessary. And we have a provision of temporary connection, and he does not need the NOC from the landlord. So by that
We'll
direction,
make sure that abiding orders in the titles. What is the title suit number?
I have a next. 76/22, your lordship. Pending before the Munsif number 1, your lordship. Title suit number
Number 1 of which district? Which district?
Sibsagar, your lordship.
All right, you are appearing for the APDC.
Yes, my lord.
And you are for?
Well, I am for the private respondent number 8. Well, I have filed my affidavit.
No, we'll see, Mr. Sharma. Let's not waste time on these matters. I'm going to allow this writ petition. The circle officer has no business issuing these orders.
Those two notice, eviction notice given by circle officer, I am also not submitting anything. My lord. I understand, my lord. But in my rented house, my lord, the petitioner.
Get an order from the civil court. The writ court can't pass any order. Yes, you are government advocate. Anything to say? What have you got to say, Mr. Goswami? All right, then you take your seat.
My lord, may I just place one thing? My lord, because of the Supreme Court recent judgment that NOC is no more required from the owner. So he can just.
We'll just make an observation since the matter is sub judice.
My lord.
APDCL will not take any action in the matter without the leave of the court.
My lord.
That's all. Heard Mr. S. Bhattakur, learned counsel appearing for the writ petitioner. Also heard Mr. N. Goswami, learned learned government. Also heard Ms. G. Hazarika, learned standing counsel Revenue Department Assam appearing for respondent numbers 1 and 2. Mr. N. Goswami, learned government advocate Assam appearing for respondent numbers 3, 4 and 5. Mr. SP Sharma, learned standing counsel APDCL appearing for the respondent numbers 6 and 7. And Mr. TR Sharma, learned counsel appearing for the respondent number 8. So stuff. The petitioner has approached this court by filing the instant writ petition, assailing the notice dated 3/10/2020 bracket annexure capital C bracket close. And before the notice is dated, 3/10/2020 bracket annexure C and 11/11/2020 bracket annexure D issued by the circle officer, Demo Revenue Circle. That is the respondent number 5 herein. Directing the petitioner to vacate the garage under his occupation on the ground of non-payment of rent to the respondent number 8. Full stop. From the materials available on record, it is apparent that even on the own showing of the respondent number 5, the plot of land under occupation of the petitioner is a private patta land, the ownership in respect of which has been claimed by the respondent number 8. The dispute apparently is one pertaining to tenancy of the land, tenancy of the premises, in respect of which the respondent number 8 has already instituted title suit number 76/2022 in the court of Munsif number 1, Sivsagar, seeking a decree of eviction of the petitioner from the garage under his occupation. Under the circumstances, it is apparent that the respondent number 5 had no jurisdiction to issue the impugned notices directing eviction of the petitioner from the private patta land. The learned counsel for the respondents have also fairly submitted that it is a private tenancy dispute between the petitioner and the respondent number 5, which has to be resolved in the civil court. In view of the above, the writ petition stands allowed by setting aside the notices dated 3/10/2020 and 11/11/2020. It is made clear that 2020 full stop. Since there is a title suit pending before the competent court, where instituted by the respondent number 8 seeking seeking eviction of the petitioner from the tenanted premises, it is made clear that no precipitate action for eviction of the petitioner and public order disturbing his possession over the tenanted premises, including supply of electricity connection, shall be taken by any of the authorities without obtaining in leave of the civil court in the matter. Read petition stands disposed of.
Deep notes.
Please, your lordship. Here, my lord, this matter relates to removal of the ward member, my lord, on the ground of having two living children at the time of contesting panchayat election, my lord. But this amended rules of 2018 is not applicable in the instant case. Your lordship may kindly turn to page 7, my lord, of my petition, my lord. Here I have given the list of children, my lord, 6 children, my lord. The petitioner has 6 children, and your lordship may kindly see the date of birth, my lord. One is born in 92, 96, 98, 2000, 2002, and 2004, my lord. And my lord.
So
Assam Panchayat Act-
affidavit, pleadings are complete?
BDO has filed affidavit, my lord, supporting the claim of the petitioner. Otherwise, the main grievance is against the Deputy Commission.
Because so cause notice was issued to the petitioner, she did not reply, perhaps that is the reason for
My
passing
lord.
of this order, lordship.
So where is the impugned order?
At page 18, my
18.
lord.
Page?
18.
18.
Yes, and what is your case?
My lord, this is the amended act, my lord. Your lordship may kindly have a look. my lord.
What does it say?
It says, my lord, it has come into force on, my lord, 19th of March 2018. It says, my lord, no person shall be elected or co-opted and remain as president, vice president, or member of Zilla Parishad, Anchalik Panchayat and Gaon Panchayat, who has more than 2 living children from a single or multiple partners, provided that this provision shall not be applicable in respect of those persons who have more than 2 children prior to the date of commencement of this act, my lord. So, and this, the date of commencement of this act is 19th March 2018.
So you have 6 children, but all of them were born before 19 March.
Yes,
2000.
Yes.
So
Perhaps he given false affidavit that he has 6 children, perhaps that is the reason. It appears from the impugned order also.
sorry,
It appears from the impugned order, the affidavit she has filed at the time of filing of the nominations, she mentioned less number of children also.
in the affidavit, how many children you mentioned?
Nomination papers are prepared by others. She only put her signature. She read only up to class 8, my lord. I have, my lord, filed my reply affidavit also.
May I submit?
I have stated.
It's not a case, my lord, that petitioner has more than 2 children after the date of 2018. It's a case where affidavit was filed with wrong information, and that is why Deputy Commissioner rejected my claim of the petition.
And the election took place in 2018, and the impugn order was passed in 2021, my lord.
And the amendments
Right
came into
after the
effect.
election, they did not.
1952.
All right, how many children do you have?
6, my lord.
6. But according to you, they were all born before 19th of March 2018.
Yes, yes.
But in the affidavit, only 2 children has been mentioned.
That, my lord.
Huh?
My lord, that, my lord, they should have pointed out in 2018 itself, my lord. But they have pointed out in 2000, my lord, 21 September, my lord. After, my lord, 4 years. They did not point out earlier.
No, but you made a false statement.
My lord, all the documents were prepared by others. She only put her signature, my lord.
All right, we'll allow the petition, but make it clear that the authorities will be at liberty to proceed against her for making, for swearing a false affidavit. But disqualification cannot be false. Take down heard Ms. S.B. Chaudhary, Learned Counsel appearing for the Writ Petitioner. Also heard Mr. N. Goswami, Learned Government Advocate Assam appearing on behalf of
Number 3.
Response number 3. Mr. S. Dutta, Learned SC PNRD Department Assam is present on behalf of respondent numbers 1, 4, and 5. And none has appeared for the remaining respondents. First up, the writ petitioner herein was elected as a member of Ward number 3 of North Karimganj Gao Panchayat in the elections, in the Gao Panchayat elections that took place in the year 2018. Subsequently, it appears that complaints were received. No, you're right. It appears that the petitioner had 6 living children on the date of her election. However, in the affidavit, in the mandatory affidavit filed by the petitioner, along with her nomination paper, it has been mentioned that she did not have more than 2 bracketed TW or bracket close living children. Subsequently, a complaint was received by the authorities to the effect that the petitioner had sworn a false affidavit, as a result of which the district commissioner bracket now as a result of which the respondent number 4, the respondent number 3, sorry, respondent number 3 had issued a show cause notice to the petitioner to explain her conduct. However, when the petitioner failed to respond to the aforesaid show cause notice, impugn order dated 15/9/2021 was issued by the respondent number 3. Removing the petitioner from the post of ward member of ward number 303 of North Karimganj Gao Panchayat. Hence this writ petition. Ms. Chaudhary submits that her client is not denying the fact that she had 6 living children on the date of her election, on the date of submission of the nomination paper. But as per the provision of as per the amended provision of section 111 of the Assam Panchayat Act 1994, the restriction of having not more than 2 children would not be applicable to the children born prior to commencement of the Act, which is 19/3/2018. First up, since all the children born to the petitioner were prior to 19/3/2018, hence, submits Ms. Chaudhary, the rigors of the amended provision of section 111 of the Act of 1994 would not at all be applicable in her case. First up, next paragraph. In her case, as such, the impugn order is illegal and hence liable to be set aside by this court. Stop. Mr. Goswami, learned government advocate Assam, on the other hand, submits that the issue was not whether the petitioner had more than 2 children living at the time of her election, but the false affidavit sworn by the petitioner declaring that she had only 2 children living at that point of time, which was factually incorrect. Stop. Mr. Goswami submits that since the petitioner had sworn a false affidavit and had also failed to respond to the show cause notice issued by the respondent number 3, the authority was left with no option but to issue the impugned order. Full stop. Mr. S. Datta, learned standing counsel PNRD Assam, has referred to the affidavit in opposition filed on behalf of the respondent number 5, that is the Chief Executive Officer of Karimganj Zilla Parishad, which supports the claim of the petitioner that the 6 children born to her were all prior to the filing of the nomination, and to that extent, before the commencement of the amended provision of the Assam Panchayat Record Amendment Records Act, 2018, which came into force with effect from 19/3/2018. Full stop. However, 19/3/2018. Full stop. After hearing the submission of learned counsel for the parties, I find that a ward member can be disqualified and or removed from office on the ground of contravention of the amended provision of section 111 of the Assam Panchayat Act 1994 as amended, if he or she had more than 2 living children prior to commencement of the act. The said provision, admittedly, would not be applicable in case of the petitioners, since all her children were born prior to coming into force of the amended provision of the act. If that be so, there can be no doubt about the fact that the petitioner could not have been removed from office due to contravention of section 111 of the amended Act of 1994. Full stop. This brings the court to the next issue as to whether any penal action can be initiated against the petitioner for swearing a false affidavit. Full stop. There is no serious dispute about the fact that the affidavit sworn by the petitioner at the time of submitting her nomination was false. Full stop. If that be so, the petitioner would be liable to face legal consequences for swearing false affidavit. However, there is no provision in the Act of 1994 to remove the petitioner from office merely on the ground of swearing a false affidavit. Is there any provision? However, it appears that there is no provision in the Act of 1994 to remove a ward member for swearing a false affidavit. What is 62? Let us see the Act. Rule 62.
It's amended, my lord. This is regarding having more than 2 children, my lord.
For swearing a false affidavit. The provisions of Rule 62 bracket
62.
numerical 1 bracket close bracket small a of the Assam Panchayat bracket Constitution bracket close bracket amendment bracket close Rules 2018 invoked by the respond number 3 while issuing the impugned order dated 15/9/2021. Apparently, the rule here, is it here? Rule?
My lord, this is the new rule, Rule 62.
Apparently. Deals with requirement of furnishing an affidavit that the candidate did not have more than 2 living children from a single or multiple partner. Full stop. As per Rule 62 bracket 1 bracket close bracket B, a candidate can be removed from the office of president, vice president, or member of Zilla Parishad, Anchalik Panchayat and Gaon Panchayat if he or she was having 2 or more children from single or multiple partners prior to the date of commencement of the Act of 19, prior to the commencement of the amended Act, that is prior to 19/3/2018. In view of the above, it is apparent that the impugned order has been issued on an erroneous interpretation of the provisions of the amended section 111 of the Act of 1994, read with rules 61 bracket 1 bracket close bracket small a of the Assam Panchayat bracket Constitution bracket close amendment bracket close rules of 2018. The impugned order is therefore set aside. The petitioner be forthwith restored back in the office of, in the post of member of Gaon Panchayat of the GP in question. It is, however, made clear that this order would not come in the way of the authorities in initiating appropriate action against the petitioner in accordance with law for swearing a false affidavit if deemed necessary. The petition stands disposed of.
Pending matter item 14.
Yes.
Lordship, this matter escaped my notice, Lordship. Copy of the order has been served upon me, Lordship. Your Lordship, will give me some time, Lordship, I will take it up with the author.
You suggest when you tell us, let's be concrete, let's move forward.
Yes, Lordship.
This time, no time, that's not important. Important is we have to deliver it whenever it has to be.
Lordship.
So when can you really come up with a, and don't just come up, you see, somebody is gone missing, wife is trying to trace out. Police has not been able to throw any light.
Political ground, he was kidnapped.
And there is allegation that there were political.
The state government, they are not doing anything because of that.
So the family member of the victim does not have, they have lost the confidence on the state apparatus. This is under this circumstance, the CBI is being, so you please take proper instruction and don't come up with these
Another
are serious
adjournment.
matter. Sorry?
Another adjournment.
No, adjournment is not the point. Point is a response.
Yes, Lordship.
So we'll give you how much time you want? Next week?
No, Lordship.
No, next week is not possible.
Let it be on 28th or 29th, Lordship.
Heard Mr. B.D. Das, Lanet Senior Counsel, assisted by Mr. Thousan appearing for the writ petitioner. Also heard Mr. R.K.D. Chaudhary, Lanet DSGY, who submits that due to oversight, the matter has escaped his notice, as a result of which necessary instruction could not be obtained from the CBI authorities. On the request of Mr. R.K.D. Chaudhary, this matter is therefore be directed to be posted again on 29th of September 2023 as a fixed item. Come up with some concrete response. Sir.
Let's
Not-
say 28th.
29th. Yes.
May I please, your lordship?
In this case, Lordship, we have filed an affidavit today, Lordship, not in the record, Lordship. No, no, next time.
Well, this subject matter is within a very narrow campus, my lord. Subject matter is that, my lord, requisition notice was submitted. Secretary has not forwarded within the time period, my lord. Thereafter, it was referred to the Anchalik Panchayat. Anchalik Panchayat also failed to convene the meeting. It was referred to the deputy commissioner, my lord. District commissioner, district, my lord. But suggesting the petitioners to give a fresh requisition notice, my lord. We could have easily given fresh notice, my lord, but that is not the fact, my lord. It would have created a bad precedent, my lord. So our prayer is that DC may be directed to convene the meeting within the short time period, my lord. That is the only prayer, my lord.
Let the affidavit, you have filed affidavit
Lodge.
by the DC.
Lodge.
When was it filed?
Today, Lodge. Today we have filed, Lodge.
You have received copy?
Yes, my lord. Today received. my lord.
What about your?
Lordship, we didn't file any affidavit, my lord. Deputy Commissioner should cover us now.
All right. We'll have it on Monday.
Lodge.
Yes. Heard Mr. Lashkar, Lanet Counsel appearing for the writ petitioner. Mr. N. Goswami, Lanet's government advocate submits that an affidavit on behalf of the Deputy Commissioner of the district, that is the respond number.
Two.
Respond number 2 has been filed this morning. Full stop. However, the affidavit is not on record. Mr. S. Dutta, Lanet's SCPNRD department submits that the affidavit filed on behalf of respond number 2 shall cover the case of the department as well. Since the petitioner is seeking an order disposing the petition at the stage of admission hearing, perusal of the affidavit will be necessary. As such, register to take the affidavit filed by the respond number 2 to the record of this case and list the matter again as a fixed item on 18th of September 2023.
Please, Your Lordship. My lord, here the petitioners are aggrieved by the freezing of his bank account by the Axis Bank, my lord, on the pretext of KYC updation, my lord. May I just first refer you to your lordship, page 27 for me.
When was the account frozen?
My lord, the account has been frozen the lastly on 22/8. There were several instances, my lord. First, it was frozen on 16/6/2023. Then thereafter again on 14/7/2023. Thereafter again on 4/8/2023. And now lastly on 22/8/2023. And all these freezing, my lord, were without any intimation and without any information for before the freezing has been done. Whereas the RBI guidelines are very specific, my lord.
Where is the RBI guideline?
My lord, I have, your lordship wanted to see the RBI guidelines from the last occasion also. The updated RBI guidelines. This is
updated up to 4th of May 2023 is the last update, my lord. I've got a copy from the RBI website.
Which page?
My lord will find page 13, page 34, page 35, my lord. What are the requirement of the KYC, my lord, for an company, my lord? It has been said, my lord. Clause B, my lord, finds if no change in KYC information, in case no change in the KYC information of the LE customer, a self-declaration in this regard shall be obtained from the LE customer through its email ID registered with registered RE, ATM's digital channels such as online banking, internet banking, mobile application, and of RE. Letter from an official authorized by the LE in this regard, board resolution further RE shall ensure during the process that the beneficial ownership information available with them is accurate and shall update the same if required to keep up to date. Change in KYC information. If there is a change in the information, then they have to ask for the documents as like it is an opening of a new account.
This account was opened when?
It was account a long back, it's almost, we have said 2 decades back, my lord.
You are for the bank?
I am for the respondent bank, my lord, Axis Bank Limited.
Yes.
Today I have filed my affidavit, my lord, affidavit in opposition, my lord.
Where is it? What is your say? Where is the affidavit? You have received copy?
My lord, I have not received.
I have sent for the copies, my lord, but my learned friend has not yet received the copy. But I have already sent for his juniors.
No, my junior is here.
Let us see what is the affidavit. What have you stated?
May I submit, my lord, in short.
Why are you not allowing him to operate his bank account?
My lord, we are not. We want to unfreeze the account, my lord, but the problem is that, my lord, as per the very face of the record, it is that he said it's a district Golaghat, my lord. As per the cost title of the petition, my lord, he has 2 addresses. One is a registered office at Letikozan Golaghat, and the other one is at Parag Bhaman Ulubari GS Road. So, my lord, as per his own statement, my lord, his registered office situated at Golaghat. So we have requested the petitioner to submit SRF form, that is service request form, my lord. In the service request form, they have mentioned that their registered office is at Golaghat, Letikozan. And my lord, as per Annexure 3 of the writ petition.
So you tell me, he will be allowed to operate the bank account. You tell me what is to be done. That's all.
Yes, my lord.
What is to be done immediately?
My lord, they have 2 addresses. When we have asked them to submit address proof of Letikozan Golaghat, they failed, my lord, they did not. And when we have asked them to submit the office address of this Ulubari Guwahati address, he has submitted his residential address of Mathuranagar Soru area, my lord. So our prayer is very limited and simple, my lord. Let them produce address proof either of Letikozan Golaghat or of Guwahati address, my lord. That's all.
Corporate address.
Corporate address. And my lord, the copy of
there's no difficulty in that, my lord. What he is saying that they have been asking for the address proof, absolutely contrary to the record, my lord. If your lordship finds their affidavit also, one document, my lord, will dismiss my petition.
Approach, see, then we'll hear the matter in the first week of October.
Your lordship will kindly have a look
What
at
is the way forward? You give him the corporate address by the end of the day, and
my lord,
by tomorrow.
That's not a problem, my lord.
Then do it, that's all. Heard Mr. B. Kaushik, Learned Counsel, appearing for the.
Your lordship will kindly observe one thing, my lord. Just bear me for 1 minute, my lord. My lord, this freezing has been done 5 times, my lord. And the difficulty which I have faced, my lord, will kindly consider that. My
Mr.
payments are
Kaushik,
stopped.
what is the order you are seeking today?
My lord, the suspension of the freezing, my lord.
That's what I'm saying. He'll remove the freezing. Why don't you allow the court to pass the order?
I'm sorry.
But this is subject to the condition that you will furnish proof of corporate office address of the corporate office of the petitioner within the course of the day.
Yes.
Only on receipt of that, within 24 hours, they'll activate the account. Awaiting further order from this court. Heard Mr. B. Kaushik, Learned Counsel, appearing for the petitioner. Also heard Mr.
P. Das,
Learned Counsel, who has entered appearance on behalf of the respondent numbers 4 and 5 on receipt of copies of the writ petition served upon the bank in terms of the order dated 30/8/2023 passed by this court. Full stop. The core issue in this writ petition pertains to freezing of the bank account of the petitioner company maintained with the respondent numbers 4 and 5 on the ground of non-compliance of KYC requirement. Full stop. Mr. Kaushik submits that the bank account has been in operation since more than 2 decades and all KYC documents have already been furnished to the bank by the petitioner. Full stop. Under the circumstances.
As and when asked for. madam.
As and when asked for. Full stop. Under the circumstances, there was no justifiable ground for the respondent numbers 4 and 5 to freeze the bank account of the petitioner on numerous occasions in the recent past, including the last being on 22/8/2023. Full stop. It is also the submission of Mr. Kaushik that under the RBI guidelines, a bank account cannot be frozen merely due to non-compliance of KYC requirement. Stop. Just hold for a minute. You are not correct on that.
My lord,
You need to check out.
the
There are
page-
many other regulations.
Page
which have-
37 is the my lord provided.
There are many other cross-cutting regulations which have come in. So we'll not go into that. Responding to the above, Mr. Das, learned counsel for the respondent numbers 4 and 5 submits that the petitioner has failed to submit address proof of the corporate office of the company, as a result of which,
As well as the local admin office of Guwahati.
as well as the local admin office of Guwahati, as a result of which the bank has been compelled to take the above action. Full stop. At this stage, Mr. Kaushik submits that the address proof as sought for by the bank will be furnished to them during the course of the day. Full stop. In view of the above, issue notice of motion returnable in 4 weeks since Mr. Das has appeared and accepted notice for respondent numbers 4 and 5.
3, 4 and 5, my lord.
3, 4 and 5. No formal notice is required to be sent to the said respondent. Full stop. The petitioner to serve, petitioner to take steps for service of notice upon respondent numbers 1 and 2 by registered post with AD within 3 days from today. Full stop. Heard on the prayer of interim relief, having regard to the facts and circumstances of the case in its entirety, it is hereby ordered that the petitioner company shall furnish proof of address of the corporate office at Golaghat as well as the local admin office at Guwahati, if necessary, by sending electronic version of the relevant document. Full stop. Upon receipt of such document, the respondent bank shall activate the account of the petitioner within 24 hours thereafter. 24 hours thereafter. However, if there is any further issue pertaining to the documentary evidence furnished by the petitioner bank, the said issue shall be brought to the notice of the court by filing proper pleadings. Full stop. But the same shall not be a ground for the bank to continue with the freezing of the account without obtaining the leave of the court. Let this matter be listed accordingly.
My lord, at paragraph number 6 of my affidavit, I have mentioned that for his corporate office address, either trade license or the latest electricity bill, and for the Guwahati address, the trade license of the GMC, my lord.
They
Because
will-
if the company is an
they
active
will give
company.
you he will give you the corporate address of
And the
Golaghat as well.
as
Rest of the things will sort it out later.
Latest copy, my lord,
And
that may be
if
recorded.
you are not aggrieved with it, then if happy with it, then also you have to activate it.
My
It
lord,
is under a
we
court
are
order.
ready to unfreeze, my lord, subject to production of the latest copy of the address proof, my lord.
That's what they will do.
Yes,
Even if you are not satisfied, then also you have to activate it. And problem, if any, you can bring it to the notice of the court. Because he is to do it as per court order. If they
But-
play a mischief, then it's going to be serious consequence for them. So let us what to Kumaidibu. In the meantime, the affidavit filed today by the respondent numbers 4 and 5 be tagged with the record of this case.
Obliged.
That's all.
That's all.
High level.